Well, hello everyone, and welcome to the City Club of Cleveland, where we are devoted to conversations of consequence that help democracy thrive. It is Tuesday, August 27th, and I'm Nick Costell, the government reporter with Signal Cleveland, and I will be moderating this evening's forum. We are at the Happy Dog in Gordon Square for a special Happy Dog Takes on Everything forum, and tonight we are taking on redistricting. Ohioans this fall, all of you, will vote on a proposed constitutional amendment that would change the way legislative and congressional districts are drawn in the state. The amendment would put the map drawing pens in the hands of a new bipartisan redistricting commission that also includes independents and people who are not elected office holders or party officials. We'll get more on the details later. First fight is happening well before Election Day as the campaign goes to court over the ballot language drawn up by the ballot board. Joining me to talk about the Citizens Not Politicians campaign is Maureen O'Connor, retired Chief Justice of the Ohio Supreme Court. And Justice O'Connor, as I'm sure you all know, played a pivotal role in ruling multiple times that Ohio's voting districts were unconstitutionally gerrymandered. She's now a leading voice in the ballot issue campaign. Also with us tonight is Dr. Kareem in the DC office of the Brennan Center for Justice. Thank you very much for being here. And friends at the City Club, please join me in Justice O'Connor, I want to start with you. Ohioans passed redistricting measures before, as we were just talking about before we came up on stage here in 2015, 2018. Why propose something new now? Did those past efforts fail?
In the words of our current governor, Mike DeWine, they didn't work very well. Master of the understatement. The 2015, 2018 were initiatives that were written, crafted, and proposed by our legislature. They were not citizen initiatives. This is a citizens initiative in 2024, what we're doing. So it's very different. Those two were crafted by, as I said, legislature, drafted by the legislature, and proposed by the legislature. And they, in my estimation, were doomed to fail from the beginning because they had what I call the Trojan horse. The Redistricting Commission that was embedded in these constitutional amendments was made up of 7 politicians. And those 7 politicians, turned out five around. It was 5 Republican governor, secretary of state, auditor, leadership of the majority party, and from both the House and the Senate, and then the minority party, 1 member of the House, 1 member of the Senate. So that was the makeup, and that was the makeup. This last map that they drew, that was the makeup that produced 7 unconstitutional maps in 2022, and that is it's an untenable situation to have politicians drawing their own maps. It's putting the fox in the henhouse, and they demonstrated that. Just not my opinion. They demonstrated it repeatedly. Their inability to follow the Constitution and give the voters of Ohio constitutional maps.
Dr. Crayton, if I could ask you to elaborate on that a little bit. This idea of putting the map pens in the hands of people who are not elected office holders, they're not, working for campaigns, they're not lobbyists. Why take elected officials out of the process?
Well, first, let me say thank you for the invitation to end this event. It's my first trip to Cleveland. I'm not a native Ohioan, but it's really a joy to be here. Looking forward to learn more. But it seems to me one of the things that we want redistricting at all times is work that's done on behalf of the people who are voters. This whole idea is to serve elections that allow people to choose. And you can't have that by definition when people, voters, are driving decision making for their own purposes. And that's really the fundamental problem here, right? I mean, on its surface, honestly, we can't expect a people-oriented decision when people who are choosing which kinds of maps, which communities are themselves the people who are running in these jurisdictions. It's, you know, almost trite at this point to say it, but when, right, the people are choosing, that is, the electeds are choosing the voters they want, as opposed to the voters choosing the electeds that they want. It's the exact opposite of what we think about in democracy. The other piece of this is, and you know, I'm sure all of you all saw it, is the process is often not transparent. That is to say, we don't usually see an instance where people, average people who are voters, who live in communities, who know what their lived experience is about how they engage with other people, what they think are communities that belong together in districts because of common concerns, they don't get a chance to speak to the decision makers about what they want. And beyond that, most important, the people who make these choices don't ever have to explain themselves. And that's always the tell, right? If they're not telling you why they're doing it, likely the choice is reflecting things that they probably aren't proud to say anything about, right? And so that really is one of the big concerns that motivates this question about needing to have citizens basically drawing the maps. Because at least if you get a map that doesn't do everything that you want it to do, and sometimes that happens, let's be honest about it. No map is going to be absolutely perfect, but every map in any circumstance that involves citizen-driven, independent redistricting is going to have to explain why. And the hope is anytime processes like these go forward, even if you didn't get everything you want, you got some of what you wanted, and you feel like you got enough of a fair shake to do it again. And that's what's missing in the current system.
Mm-hmm. If I could stay with you for 1 second, as you talked about, you know, you may not get everything you want out of a map. Could you go over for us what are the things that you think, you know, the qualities that represent a fair?
Well, if you look at the proposal that's on the ballot, what you see is that there are a lot of different priorities that have to be taken into account, right? Anytime you draw a map, you're drawing a map for a huge state like Ohio, one of the largest in the country. You're thinking about a lot of things, but most important, you always have to think about what the law requires, right? You have a federal and a state constitution that says there's something you absolutely always have to do. I, you know, represent an organization called the Brennan Center. One of Justice Brennan, the namesake of the organization, one of his key decisions on the court was about one vote. You got to comply with that. How you do it depends on, you know, the level of districts that you're drawing, but you take into account once you with the things that you absolutely have to take care of, like the law of one person, one vote, like the Voting Rights Act. There are a lot of different things you can do. And those are the moments where you think about, well, what is it we're trying to accomplish? If you're in a city, the city might be so big that it could be in one district. Maybe it's not a good idea to divide the city into two, as a lot of gerrymanders tend to do because they don't like the politics of the city. It's easier to overwhelm the politics when you divide it. Or put differently, there are a lot of rural areas of states that are small enough to be within a district, but in order to serve a particular partisan end, it gets split 5 ways. I've seen that. I've done redistricting all over the country. What you see is common in gerrymanders is all those considerations that are specific to communities tend to get submerged into a very, I'd say, short-sighted and very partisan-driven answer of what gets me the number of people in the legislature that will serve my interests. That totally ignores where the people are, what the lived experience of people would be. And that's really why it's so important to have a process that has input from voters to say, well, this makes sense because, and this is why you see neighborhood associations, groups like this that usually get together, talk to decision makers to say, here's what we think kind of makes sense, and maybe here are 2 or 3 ways to do it. We want you to take into account all the different considerations and try as best you can to kind of meet that need. And again, that's where we get to the point of it is a small p political decision. It's a puzzle. And not every part of the puzzle is going to fit perfectly. But what we hope to see if citizens are driving the action is an answer that gets pretty close to right so that you can see in looking at it, all right, they tried to get this, and maybe they were 100% effective at it, maybe 80% effective. But most important, you see why they did it. And maybe you see some of the important considerations that meant that they could only get to 80%, but not 100%. That's what's so important about it.
Now, in a moment, I want to get this idea of how partisan makeup fits into those districts. But Justice O'Connor, I wanted to ask you first. One of the arguments that I've seen against this proposal is, and it may not be put exactly in these words, but the thrust of the argument is political power, whether that's drawing districts, writing legislation, or even deciding court cases, ought to belong to people who are elected because the voters serve as a check on them. Don't like what they did, you can vote them out. And if you have a redistricting commission that is not elected, the voters don't have that recourse anymore. What do you make of that argument?
The argument, one word for it, is accountability. And that's what the opposition is saying, that this proposal, and if it is implemented, would lack accountability. I don't think it's very accountable to the citizens of Ohio to put forth 7 unconstitutional maps, and when directed by the court, repeatedly thumb your nose at the directives. So to speak of accountability by the opponents is laughable. And the system, the 15 members, right? And maybe you were going to get into this about the makeup of the,
Please go right ahead.
Commission, but they're a 15-member commission made up of citizens, not politicians, not people who are active at party headquarters, not people who have relatives that are. These are pure citizens who are not concerned about a political outcome. And that is what the huge difference is. And that in and of itself, I think, exemplifies accountability. And when they are taking things into consideration, things that are embedded in the Constitution now, there are the protections there that for their work product, how they're going to be doing their job. And here's the other thing that makes it so accountable. Everything is going to be televised. Everything is transparent. You will see whatever discussions they're having as a group, you can attend, all right? Or you could, in the comfort of your own home or at your desk, watch it, live stream. They have mandatory meetings that they must do around the state. So they're hitting all of Ohio initially to get the input. You spoke about communities of interest and how you figure out those communities of interest. The people tell you what their communities of interest. And then maps are drawn based on the information that's given and the criteria, the Voting Rights Act, etc. And then they circle the state again to get input from the voters. Unheard of.
One thing that was interesting to me as I read through the proposal is the degree to which these proposed rules would try to keep out people who are involved in political activities. You can't be serving an elected office to be on the commission. You can't have recently served an elected office or run for elected office. I wonder, does that even keep out people maybe who have been involved in sort of low-level local politics, like a precinct committee person or someone who has worked on a local campaign, who maybe, they could be involved in this? Or are we keeping people out who might otherwise have something to say?
They will be able to have their say in front of the population of Ohio because of the transparency. If someone is active and representing their party, no matter what party it is, and precinct, you said ward, working board of elections, whatever. Even though board of elections, should be a neutral, but if you are employed in those, plus many of others, lobbyists won't be able to be serving on this or have any influence. And I urge you to read the Constitution because of the very prescribed description of who can and who cannot be part of it. So again, those people are not stopped from giving their opinions, talking about it, participating in the transparency of the discussion. They just won't be the decision makers.
Right. It sounds like, to go back to a point that you just made, Chief Justice, and then I'll go over to Dr. Crayton, to the question of why should the legislature not be doing this anymore. It sounds like you were saying they've demonstrated through their own actions that they shouldn't do this anymore. I think that the way they have done this is what has disqualified them from doing it in the future.
I do believe that the focus on retaining political power, and I want to emphasize this is not one party problem. Both parties are guilty of doing this given the opportunity, and that's been demonstrated around the country. And so, there's the was it Center for, I forget what the name of the institution is that reviews all these redistricting independent commissions, And they described Ohio's proposed as the gold standard. So it's better than, in their estimation, you know what I'm talking about. Anyway, I'll in my notes, but it's an organization that the reviews has a citizens interaction that is relatively new. California has one, Arizona, Colorado. These are all, we looked at all of them. Iowa, you've heard that. That was supposed to be one that was touted as would be a great thing for Ohio to adopt. Iowa, the legislature is the end game, and no, it would not work in Ohio. But my point is that we were able to look at all of the commissions, how they operated, how successful they were in achieving their goal, and taking the best of what we studied and tailoring things to fit the needs of Ohio.
Well, a question for each of you, and Dr. Crayton, we'll start with you, is, you know, one thing I think about when we're talking about redistricting is sort of what is the ultimate goal? What is the type of district or the makeup that you want to have? Is it more important to have districts that are competitive, where a Democrat or a Republican can win, whoever is running the best campaign, or districts that lead to an outcome that is proportionally representative of how the state votes?
So I think the main answer to that question is this is a decision that should be made within the constraints that law sets out by the people. That's one feature of a district that actually it's a small p political question. It could go a lot of different ways if you're thinking about the margins, and that really depends on how it fits. Like, what are you trading off? Are you trading off in a particular approach, like you might want like competitive districts? If it means splitting a community that you think is really important, maybe you don't want that. But the point of this process is, again, within the existing constraints that the provision allows, that the people should be able to engage in a conversation. The decision makers can, in conversation with the people, make the best judgment that they can. So there's a theory for pretty much everything, right? That is, whether competitive districts, like right on the margin of 50%, serve the interest of the state better than a district where, on average, we think, as actually this provision asks to take account of, if you look statewide, that should roughly be in proportion to the will of the state as it's expressed over a series of elections. As it looks in any particular area, there are trade-offs anytime you make a decision about a particular district. The question should be driven not just by some presupposition by the decision makers alone. It should be in consultation with the communities that are actually going to be governed by these decisions. I just want to turn it back there briefly to the point that the Chief Justice made. I've taught for a number of years, and I think about the world often as both in the academic world and also in the political world. And in both places, you're usually trying to defend a record. It's either a record that you amassed as a politician and accomplishing things, or a record as a student, like how well you did on your report card. And if you're trying to defend the existing system, what you have to defend is 7 times groups of people trying to get what looks like a fairer map, and the legislature saying no. You have to defend a group of people, this group of decision makers from the existing system that had literally one session where they allowed the public to engage. You don't have to be a fancy lawyer to understand that doesn't look like democracy. The purpose of this is to serve people. And that's really where the other side in this argument has to have a hard time. They've got to convince you that that makes any sense. I don't know that anybody, whether or not you've been to law school, thinks that that's a system that is workable. But that's really what we're actually facing. And then we do better than that. I think this provision presents another way. And so I want, as you're thinking about whatever happens with the Ohio Supreme Court, don't let any of these shenanigans cloud that truth. You've got an existing system that really doesn't function, and you have a way out that really is, to your point, Justice O'Connor's point, it is the gold standard. The Independent Citizen Commission has been shown to be really the most effective way of crafting districts that meet the public's needs and that fence out or insulate as best one can the sort of self-dealing politics that typically happen when politicians get behind the map and try to craft what they want.
Well, and to put that to Chief Justice, go right ahead.
I was going to follow up with the concept of representational fairness, proportionality, the the topics of having a balance, whether you want 50-50, do you want 54 7 or 46. Anyway, close enough. That, as I said, has to be supported by evidence. Okay, you just don't pull those numbers out of it. There's a formula. There's guidelines within the Constitution, and you will hear criticism of the fact. In fact, if you look at the ballot language that was drafted last Friday, it says the exact opposite of what the constitutional amendment says. It says that the Redistricting Commission is required to gerrymander the districts. That's actually the words they put in the ballot initiative. And they're hoping that people will vote no. I would vote no if that was really true, but it's not. We want you to vote yes. And I can't say that enough. I should say it more than I do. Vote yes. People get it, yes. But my point is, this is one metric to look at. When we were doing, when I was at the court and we were hearing cases, they had proportionality numbers that they thought or said corresponded to how it was voted. And they had districts in the D column and they had districts in the R. Those in the R column were 53% in the R, 54, maybe higher. The D column, I will never forget this, 50.003. That wasn't in the competitive district column. That was in the Democratic column. So it's all who has the pen in their hand and what their motivation is. And what I just explained to you is a perfect example of motivation that has no business being in this activity, this exercise.
Well, and to stay with you, Justice O'Connor, I mean, if you look at the language in the proposed amendment, you are looking at election result data over the past, I think, 6 years as a way to come up with this proportionality measure. Taking the past 6 years as an example, Republicans have done pretty well in the state. And the ultimate proportions you'd come up with are still favorable to Republicans, but less so than the current makeup of the state house. Can you maybe explain for me why this does put a premium on this idea of proportionality, reflecting the statewide partisan preference of the state, rather than some other quality like competitiveness?
Well, an honest map drawing, taking into consideration the formula, proportionality formula that is in there 6 years. And yes, Republicans have won more statewide races than Democrats, but you just don't count the races 1-to-1. You count the number of votes that have been cast, and that gives you your proportionality. Okay. Initially, the first go around, the leaders in the legislature said, "No, we're just going to count the offices, and we're going to do that in a proportional basis." And so the majority party thought that they needed 81% of this formula. So no, it doesn't work that way. So obviously it was lowered, and that would be fair. And I don't care how it turns out. I don't care what the numbers are. I don't care how many Republican leading districts, how many Democratic leading districts, how many competitive districts are, as long as it's done honestly and it's responsive to the citizens of Ohio and respects their vote, and not just their vote, in 2024, but their votes for the last 6 years prior to that. And that is not what was taken into consideration here. And it was, in some ways, it was the language, and again, of the two amendments, 2015 and 2018, because all the board or the commission was responsible for doing was to attempt to, and then they gave you some duties they had, not you must, or this is, the only thing you should be considering. And it was, I call it feasible. You can attempt to it. It's like, Mom, I tried, but I couldn't do it, and oh, that's okay. You got an A for effort. No, you can't do that. It's too.
Now we're about to turn over to your questions. So I hope you've been thinking about what you would like to ask our panelists. Before we do, Justice O'Connor, I do want to ask you to close out this section here. Suppose this passes, maps are drawn, and people don't like the maps. What is their recourse? You're going to hear opponents in this campaign say that there is not enough accountability. What do you say to that? What recourse will we have if they don't like the map?
There's two junctures that you have to address for that question. One is they go around, and hold at least five hearings around the state. They hear from everybody. For example, they hear from Shaker, and they say why we have the greatest school system. I'm not saying they do. I'm just saying they do have the greatest school system, and that's a criteria, and that's why we ought to all be kept together. Or there's some little poor school district in the 6th congressional district, school buildings, and it's divided in half. That's the kind of monkeying that could happen, but it's something that they have to take into consideration. So they go around the state, they get the information. Their map drawers that are professional, accomplished, have a record, they draft a map. They go around the state again. People can weigh in, and they don't have to do it in person. You can do it online. All kinds of avenues for sharing that information, and they'll take into consideration the criticisms or the support that is given around the state. If it can be, in other words, it's legitimate concerns with the map and not just superficial, and they take into consideration everything that is laid out in the Constitution when they drafted them the maps to begin with. The commission then votes on it, and that vote then that map that comes should be good for 10 years. Undoubtedly, there will be a legal challenge to that map. It will go to the Supreme Court, and then it will be decided in the Supreme Court. What if the map is that comes out of that process good for 10 years instead of the 2 years, 4 years that we've had in the last decade?
If at the risk of getting too into the weeds before we turn to questions, on the issue of court count, I was very interested to see that this proposed amendment also gives a prominent role to special masters who would review some of the evidence and actually make a recommendation to the court. Why, maybe for each of you, why give them such a role in this process? Dr. Crayton, we can start with you.
Start.
Yeah.
I want to take you back to the earlier question that you asked about why have a provision that talks about proportionality.
Sure.
All of these things are intended to be a double check on the work that's done by the commission. We think of this, and it's important to remember, right? The people drawing these maps are going to be you all, Ohioans who are interested in trying to do well on the part of the state. And there is something special that tends to happen. We've seen a few of these play out where you get people who, don't know each other, but know that they have a common job. And the job is to do good work on behalf of the state. They tend to get invested in a good way. And they work in concert across party lines often, because the provision requires them to try to get a good answer. But if they don't, or if they miss a thing, what have in this as an extra check is court review that is informed by people who are experts who can give the court. Judges don't do a ton of redistricting stuff now, of course.
Some of us
Ohio
have.
is exactly, unfortunately, an exception, but you have great people doing the work. But sometimes it's sort of landscape view from experts to say, well, here's how we think this map fits into the possible ways that one could have drawn the map, to help inform the court as to whether this looks like an outlier or looks suspicious and worthy of additional review. So that's really all this is. It's not that special masters have the final say. It's in some ways a more broad look, given the criteria that have been laid out in law, that helps the judges get a sense of how to locate this decision among all the different decisions that could have been made. So again, if you're looking at this as an Ohio voter, at the end of the day, you should hopefully feel like you've had a chance to have your say. You should have an opportunity to read the work that the commission has produced and their explanation for why. Even if you don't buy all of that, you now have independent people looking at this map on behalf of the court to help them assess whether or not it's a fair map. None of that's available to us right now. That's not guaranteed in the present system. So the whole point of it really is to build confidence that what comes out of this is something that you should actually feel good about. And even if you don't get everything you want, once again, there's a reason to at least see, okay, here's why. And maybe next time, see some changes, we might come out a different way.
Well, thank you so much. We'll go to questions now. I appreciate you holding for just a moment. Again, I am Nick Castell, government reporter with Signal Cleveland, and the moderator for today's conversation. Joining me on stage, you've been hearing from Dr. Kareem Crayton, Vice President at the Washington, D.C. Office of the President at the Brennan Center for Justice, and former Chief Justice Maureen O'Connor of the Supreme Court of Ohio. If you are with us in person, you can line up next to this microphone to my left and ask your question. Or if you're joining us virtually, I've got the number for you. You can text your question to 330-541-5794. Again, that is 330-541-5794. City Club staff will try to work these questions in. A reminder, if you would, keep your question short, to the point, and end it with a question mark if you would not mind, and we will be able to get to as many as possible. We'll begin with our first. Thank you.
Yeah, one of the things that the No campaign is saying is that the public will have no input on this at all. Do they give any evidence for this, or is this just a flat out lie that they've just sort of pulled out of thin air?
Justice O'Connor will go to you.
I know what they're saying, and it's untrue. So why they're saying it, whether they are misguided, whether they're accidentally wrong, or whether it's intentional, it's not true.
I know that if you wouldn't mind elaborating, at what points does the public have input in this process? I know there are a few.
Normally, do they have input when they're taking evidence around the country or around the state? On several occasions, more than several occasions, that the entire 15-member panel will be listening. But there will be opportunities to write if you are not going to be there in person. There's opportunities to use your laptop, whatever ways to communicate what you think, whatever the topic is. So there is ability to influence, and I mean that in the best way. Give evidence, give information, not influence incorrectly. And one of the things they're saying is there's no accountability. These are unelected bureaucrats, and you can't remove them even for a felony. So maybe everybody, anyway, that's ridiculous because there is a method. It's in the Constitution for their removal. Say they just don't show up to work, they can get removed for dereliction of duty. There is a process, and the other commission members, who, by the way, are vested in how this is operating. They don't want, dead weight. It's too important. That they will hold each other accountable. Absolutely.
And one of the elements of this, we will get to your question then. I know this got a little bit into some of the argument over the ballot board language. Is there is a requirement that the public input in this process happen in public, and if people try to make, you wouldn't call it out of court statements, but something in that vein. If a lobbyist calling up a commission member and saying, "Hey, can you do this?" the commission can decide whether to make those communications public for all to see.
That's true. The example given by is if I'm at my kid's soccer game and somebody comes up and said, "Hey, I think you ought to keep this street and that street together in the same district," and the way he portrayed it is that's a capital offense, and the handcuffs will come out in a minute. No, none of that is in this measure, the constitutional amendment. Who is obligated there is the commission member to then go to the commission and say, "A neighbor approached me. I want to be totally transparent." You can argue with that. Totally transparent. This is what was said to me, and what shall we do with it as a commission? That's the kind of stuff. That's what we're talking about. And I anything more serious, obviously, would have different consequences if somebody was trying to bribe the commissioner or threaten the commissioner or something like that. But he was not talking about that. He was talking about the innocuous little example that I gave, and that's to turn the public off as to the entire constitutional amendment.
Thank you very much for waiting. Question, please.
My question is, how are commission members appointed, and who can remove a commission member?
Dr. Crayton, we go to you and go from there.
In the top level version of this, and I would also just note that we go into detail and materials that we're happy to make available to you. But the top line version of this is first, thank you. Anybody who's eligible to vote in Ohio, absent the connections to politics, is eligible to apply to be a member of the commission. The way in which they're chosen to start is a group of retired judges of varying parties sit down after being selected and make a decision as to the first portion of the commission. Right? They call the initial pool of people down to a small group, and they choose essentially it's the first half of the commission. The commission, what's appointed by that segment, that is the set of retired judges that appoint the commission. Once they're constituted, they then appoint the rest of the commission. And in the commission, as it was, as Chief Justice said earlier, we have a requirement that there be 5 Republicans, 5 Democrats, 5 independents. So, and in addition to that, of course, it needs to be representative of the state in terms of communities, region, etc. So it really is intended to make the effort one that really gets a group of people that's insulated from the typical politics, partisan politics of what we see now, and to give an opportunity for a group of people to be constituted in a way that they see each other as jointly committed, if you will, to the enterprise. And the Chief Justice mentioned the Google. I'll let her talk a little bit about that.
Well, I want to just back up and talk about how the judges are
Yes.
selected. We will put information out there that the judges, retired for 6 years or more, and not politically active, and don't have family members that are politically active. A lot of judges' children become judges, and so a lot of my friends who are retired a long time are precluded from being on this. But there's a pool of judges. Let's say we've got 12 judges that fit the description and the criteria of what we need. Then we look to the ballot board, and we look to the 2 Ds, 2 Rs on the ballot board, and the ballot board is 5 members. Well, we thought we would pick an entity that is provided for in the Constitution. So it can't be a committee or an entity that the legislature could dissolve. And then what would we do for our constitutional amendment, right? So we picked an entity that was in the Constitution. That's the ballot board. And we said, okay, it's evenly weighted, R's and D's, when it comes to membership. But there's one member that we don't want involved in this, and that would be the Secretary of State. So it's the ballot board minus the Secretary of State. And they pick the judges. Now, the D members of the Secretary of State, the ballot board pick the R judges, the judges who are registered, they're affiliated as Republicans, and the Republican board members pick Democrat affiliated judges. So there's a pool there then that whittles down then to 2 judges on each side, each political party. Then they start the vetting of the applicants. The application will not be just check the box type of an application. We want it to be much more telling, and we would understand. Questions would be asked, motivation. So people can answer in paragraphs and sentences. Can really show us. I say no, it's not me. Show those that are making the decision that they should be in the first column of the group. Okay, and then that is whittled down to 45, 15, 15, and 15. Out of those numbers, then those 4 judges pick 2 R's, 2 D's, and 2 independents. Okay, and that's a random type thing, but they have to be mindful. Anyway, the judges do that, and then those equally balanced members, there's 6 of them, 2, 2, and 2, they will then look at the pool and keep in mind demographics and geography, etc. They will then pick the other 9 who will be on the board with them, or they should be on the commission with them. So I know that's a lot of detail, but trust me, it's a very workable method of doing it, very non-independent, and I think it is not could not be described as partisan in any way.
Now, if I can ask about the removal, and then we'll get to you,
Sorry.
is looking at the provision here, this says a commissioner shall be removed only by the commission and only for cause. You've got a notice, you've got a public hearing, and you've got a few different reasons for removal, whether that's failure to disclose information, disregard for the provisions of the amendment, wanton or willful neglect of duty, incapacity, everyone's favorite moral turpitude. You're probably going to hear critics say that saying only the commission may remove a commission member is not sufficient accountability. What would you say to that? Either of you.
Well, I think that I would beg to differ.
Sure.
You mentioned, and I think Doctor mentioned that when this group comes together, there will be a cohesiveness that has been demonstrated in other commissions in other states where they are joined by the duty and by the commitment, by the oath that they take. So these are people that are not frivolous and not doing it, on a lark. They're committed. And I think they will take their duties and their responsibilities and what you take into consideration if someone has to be removed from the commission. So I'm confident that it is a responsible way to do it. I'm confident that it will work out because it's worked out in other states. And I think it is laughable that the legislators who are opposed to this, same legislators who voted on 7 unconstitutional maps, are talking about accountability and failing the system.
Will, thank you. Your question, please.
Thank you. First, Chief Justice, thank you so much for your advocacy and your work on this issue. My question is, I remember back in 2022, there were maps that were twice declared unconstitutional that ultimately ended up being preserved by a federal court. And I also have seen, like in other states where you have independent commissions that have faced federal legal challenges that have seen their results overturned as well. What's the message to voters who are concerned that even if Ohio revamps their process, that it ultimately could be overturned by a federal court in the long run?
Dr. Crayton, we'll go to you.
Sure. I'm happy to start. And I'm going to start by saying that's another of the misconceptions and misleading efforts that the Secretary of State and the ballot board, the majority of them, imported into this language. They say, but there's no opportunity to get court access. In fact, there is. And only do you have direct appeal to the Ohio Supreme Court, as you rightly mentioned, for better or worse. Federal courts are also a place that you can take the federal issue to. So one of the protections you should think about is, particularly with this court, this current ideology on the United States Supreme Court, there is usually sanctity placed in the expressions of the law as states would have it in their constitution. If we take that as given, pray God that it continues, because I respect the ability of states and the people in those states to say what the law is with respect to their state constitution. A federal court should be bound to respect those decisions. But that is at least a place where if there is some serious breach, it has to say things like the Voting Rights Act or nothing in this provision does anything to undermine your ability to go to federal court. In fact, it very explicitly says that's one of the priorities. In fact, one of the early priorities that the decision makers trying on the commission have to account of. And so it's really important. That's at least my initial response.
I'm interested in this federal court question since we've got some time here. Justice O'Connor, I'll ask you. The Supreme Court did rule on, it did take up a gerrymandering case and issued a decision in 2019 in North Carolina. Correct me if I'm not summarizing this correctly, but essentially kicked it back to the states and said, we don't want the federal courts to be involved in this. This is a state issue. Do you think there is much federal court appetite anymore for making decisions about districts at all?
I think it ebbs and flows. I think we're talking about the Russo case.
It's correct.
All right, and Chief Justice Roberts said at that time, this isn't a topic that we should decide in the Supreme Court. I'm just paraphrasing. And this is a political decision. This is politics. And we're not meant to decide political things. That push that back to the states and let them deal with it. And basically, that was the substance of the Rucho case. So in some ways, I think it's good because it squarely puts this decision making in the state with the state Supreme Court, and you look at your state constitution, and it's closer to home. The decision making is, and I'm hoping that maybe people will accept them more readily, whatever the decision is. But since then, there has been a paring away in this court of provisions of the Voting Rights Act, and so it's when I said it's closed, that probably is depending on what the topic is and what part of the Voting Rights Act and what the subject matter is. I think about the Texas case. There was.
Well,
If you want, or we can go to
All right.
Matthew. Let's make sure we get you here.
Yes, thank you for speaking about the potential back-end mechanism of courts and special matters. But we in Ohio have seen that while we should expect our courts to be politicized, our courts, because they are comprised of elected judges, are not necessarily immune to those political considerations. We've seen, for example, in the Chief Justice, who were replaced on the court, and then the vote on the more recent redistricting challenge, as well as the Berkheimer case, the boneless chicken case, which was decided along party lines. So what might you say to somebody who is worried that the Supreme Court might find some way to either refuse to redraw a non-compliant map or might choose to sustain some kind of bad faith challenge to a compliant map and force a redrawing that is less fair than the map that the commission comes up with? Thank you.
There's so many things in that question that possibly happen. Well, first of all, I'm going to remind you all, and I probably don't have to, that there's 3 races on your ballot for Supreme Court justices this year. So we'll be voting on 3 seats. 2 of them are incumbents, and then one is what we call an open seat. So don't forget about that. But depending on what the reason is, the court would give for an opinion that is less than satisfactory to one of the parties, would determine whether they have recourse in the federal system after that. So, it may not be the final say by the Ohio Supreme Court if there is a rationale or some underpinnings that will get you over to the federal court. That's the only way you're going to have the ability to negate what the decision would be. If there's not a federal issue there, then there will be final.
Sure, and great.
I just want to underscore something the Chief Justice said earlier, too, about where the federal courts are. The federal courts certainly said in Carolina, I'm sad to say, that was a case that had a team that I managed at the time. We did the best that we could. But notwithstanding the court's hands-off view about partisan gerrymandering not being a federal issue, what they have said in past cases is, in instances where the citizens have decided, in places like Arizona, to have an independent commission to draw maps, that is the expression of what the Constitution demands. And no matter what the legislature or anybody else says, say maybe what the state Supreme Court might say about the state Constitution, the people, the state elected, get to say what the law is. And so if the court holds true to that line of cases, it should be something that if you do find that a state Supreme Court undermines the expression of what the people have said should be in their Constitution, that itself becomes a federal issue related to due process. But I think there are ways of defending, should this pass, that allow for even the bad faith efforts to undermine it to be fought against, not just in the state system, but in the federal system. But the important thing is getting the law on the books. And I think actually the best proof of it is really to watch the thing work. It has worked in so many states in a way that has actually really, again, built confidence in the process and shown citizens that they can make their own choices about how ought to be drawn. And just to be clear about, not only do citizens have the ability to say to the commission what they want, they get to show them what they want. Nothing prevents the average citizen from creating a map and showing the commission, hey, not only can I describe to you what this, configuration looks like for my community, I'm going to show you in a map. And that's actually more power than most of the time you get with legislative processes, because by the time people sit down and actually have a vote on a thing, trust me when I tell you, they've already drawn the map and they've gotten the votes. This whole thing that you see in public is always a show. The show, in the instance where citizens are driving the action, is actually where you actually see decisions made because of transparency. So that's a real benefit and advantage of this.
Right. If you want to, you can go online, go to Dave's Redistricting. You can draw your own maps. You can draw your own city council boards and see how you do. I do want to follow up on Matthew's question here. I think Chief Justice, embedded in that question was another one, which was, what if the Ohio Supreme Court makes a decision based on political considerations? Do you think that is a risk?
I think that any court can come to the wrong conclusion. I'm not going to attribute motives or reasons as to why they got it wrong or why they got it right, or that's not something that I think would be fair to comment on. But I think it's important to realize the force and effect of our Constitution and loyalty and the respect that we as citizens, and especially as office holders who take an oath to defend and obey the laws, the constitutional laws of the state of Ohio, the constitutional laws of the United States. And those are oaths, no matter what your political persuasion is, people take extremely seriously. That goes to the core. And we have members on the Supreme Court, just like we have members on the United States Supreme Court, that look at the text. And if it's unambiguous text, go to the dictionary and figure out what those words mean. And that's how they figure out the clause or the sentence or, the part. And that is not, I don't think that is as subject to abuse as other methods that other judges would use to look at it. It's pretty, some of our justices are very consistent in relying on the dictionary for interpreting words that are the subject of dispute.
We have some online questions.
We have a text question, and it's a little forward thinking. If we jump ahead, the amendment passes, survives the Ohio Supreme Court, and a map is drawn for the next 10 years. What does Ohio look like?
I don't know what it's going to look like, but if it's all done fairly, it's what it should look like.
Yes, Dr. Crayton.
I want to offer one point, and I am generally in full agreement with that. But what I will say is, with the present system, what we know is you have way more Ohioans than anybody would suspect who are in districts where the outcome is determined before you show up at the ballot box. And that's either because people don't compete, there's only one candidate running, or it's so stacked that no matter who is also running, there may be multiple candidates, the outcomes will be predetermined because of whether they have a deep or not. Turnout in these jurisdictions almost always is lower. And so what we can say is, no matter what happens to ours, because people are invested in what the districts look like, more people are going to show up and have their say. And to me, again, no matter who wins, that's good for democracy. We want, I think, to have more of the people who are eligible to vote show up and say what they want. And that way, the people who actually make decisions on your behalf actually know what you're asking them to do. Because in the absence of that, if you're not talking, I can tell you who is talking. And there are a bunch of people with interests that don't necessarily reflect yours. And they get paid to do things that, on behalf of their clients, want the world to look a certain way. That's a lot of things. That's not what I call democracy. And so I think this process that makes it much more likely that you get greater public involvement in elections, and that's
And if I could just supplement that with the observation that by far, Ohioans are independent voters. They are not affiliated with the RD. There's about, I've seen figures anywhere from 75 to 77% of Ohioans are not affiliated with a political party. That shocks people when they, but think about it, in our primary system, 75 or more percent have no voice in who the candidates are going to be for statewide offices, for local offices, for the judiciary, etc. That, if I were, I'd probably want that examined, but that's what we have in Ohio. And so their only opportunity then to have say, so to speak, even though the preliminary competition has between candidates has been decided by other people, is in the general election. And they should be voicing their concerns and go to the the polls and take a look at this constitutional amendment and say it's not redoing the primary system that we have. I get that, but at least it's going to give me a say in the general election, and I'm not going to have a candidate, a district with one candidate. I might as well stay home. And we'd like to, emphasize that. That's one of the consequences of this constitutional amendment. And also, this is for the General Assembly, but it's also for Congress. And a lot of people forget that the districts are drawn not only for the General Assembly, but also for the United States Congress. And think about how consequential that can be for Ohio and the nation. And I will give you an example of how consequential it is, because just this afternoon, the Speaker of the House, Mr. Johnson, was in Cleveland to have a fundraiser for the opposition to this constitutional amendment. I think that tells you how important this constitutional amendment is, ladies and gentlemen.
Well, thank you both very much. We are out of time, although I'd love to keep talking. So thank you again to Dr. Crayton and Chief Justice O'Connor for joining us at the Hockey Dog. Now, before you all go, I do want to say forums like this one are made possible thanks to generous support from individuals like you, and you can learn more about how to become a guardian of free speech and make a donation today at cityclub.org. Today's forum is also part of the City Club in the Community series sponsored by Bank of America. And speaking of ballot initiatives, on Friday, September 13th, the City Club will host a conversation about the Cleveland Metropolitan School District school levy, the hottest race no one's paying attention to. We will hear directly from CMSD CEO Dr. Warren Morgan and Board Chair Sarah Ellicott on the levy and the bond issue, which will appear on the November ballot for Cleveland residents. Tickets are available for this forum at cityclub.org. That brings us to the end of today's forum. Thank you very much. We are adjourned.